Hello, everyone. Welcome to concurrent session B6, the Métis Community Diversion Program, addressing justice-involved Métis needs. My name is Ken Zolitar, and I'll be your facilitator for the session. Before we get started, I wanted to review some quick housekeeping notes and then introduce our speakers. Please note the Zoom toolbar at the bottom of your screen. You can use the Q&A feature to submit questions throughout the presentation. Mitch will review these questions at the end of the session, and he'll do his best to answer as many in the time that we have. Please ensure your microphone is on mute until the Q&A portion of the session. This session will be recorded and uploaded to the conference website. You will also be able to access the platform for 90 days following the conference. I would like to remind everyone that we have closed captioning for all of our sessions. Please click on the CC icon below the video window on your screen to access this function. We also kindly ask that you complete the evaluation for this session by clicking on the session agenda on the virtual platform. There will be a survey button at the bottom of the session next to the join button. Your feedback is appreciated and will be used to inform future events such as this conference. We'd also like to respectfully ask that all those attending today's session engage with each other thoughtfully and always consider the impact of your words and interactions on others. As facilitators, we will not tolerate any abusive or inappropriate behavior or hate speech, and will ensure that anyone who engages in such behavior is removed from this session. If you have been disturbed or affected by such an event, please do what you need to do for yourself. Take a break, step outside, practice deep breathing, and/or reach out to someone you trust. If you are in a crisis and require immediate support, please click on the FAQ icon on the conference homepage to access contact information for Connex Ontario. If you'd like to report an incident, contact the event manager, Sherry Sim, by either clicking on the assistance button on the top right menu bar of your screen to send an email, or you can text 416-605-5975. I would now like to introduce our presenters for this session: Maria Guiho, Michelle Frenette, and Colin Sawchuk from the Métis Nation of Ontario. Thank you.
Thanks so much, Ken. I appreciate it. Like Ken said, we are from the Métis Nation of Ontario, specifically the advocacy program there. We're going to do a little bit of introductions before we get into our presentation here, and I'm going to start us off. So my name is Mitch Frenette. I am the supervisor of the Métis Community Diversion Program, again in the advocacy program at the Métis Nation of Ontario. I've been with the MNO for about a few years. I've had some experience as a clerk and court registrar in the criminal justice system. And I'm originally from Region 1, which is the Kenora Treaty 3 area, but now I reside in Ottawa. So without further ado, I'll pass it over to my team. Maybe let's send it over to Conlon.
Thank you for that, Mitch. Good afternoon, everyone. My name is Conlon Delbar Sawchuk. I'm an MNO citizen originating from the Red River Settlement. I am a licensee, although I am not practicing in my role. I have been in my role as a Métis Youth Community Diversion Coordinator for just under 2 years. And I'd like to pass it to Maria.
Hi, everyone. My name is Maria Guiho. I'm a Métis Community Diversion Coordinator for the Métis Nation of Ontario for Region 7, so Barrie and surrounding areas. I'm a registered social worker, and I am a settler of French and Ukrainian descent. So I'm just going to pass it over to Mitch one more time to explain the Q&A function before we get into our presentation outline.
Yeah, thanks, Maria. Just a reminder to folks, Ken had mentioned at the beginning there, but if you do have a question, I do ask that you put it in the Q&A function in the Zoom. I'll be answering them as we go along. You're also welcome to ask your question over voice at the end of the presentation. But if you have one during the presentation, please use that Q&A feature and I'll make sure that I answer it. Do not put your questions in the chat because I won't be looking there. So yeah, I will pass it over to Maria when you're ready there, Maria.
Thank you. Okay, so today we will outline who the Métis are in brief, Indigenous overrepresentation in the criminal legal system, tips for interacting with Métis people, the Métis Nation of Ontario's advocacy programs, restorative justice, the strawberry life cycle as our diversion process, our diversion circle format and phases, program success stories, obstacles for advancement of restorative justice initiatives, and we will end with questions.
Thanks, Maria. So who are the Métis? The Métis began through relations between European men, who were mainly Scottish and French, and First Nations women, mainly Anishinaabe. Through these marriages and then intermarriages of these mixed ancestry individuals, a new people bore their own distinct culture. The Métis predate Canada and the United States. Our people and our culture are over 400 years old. There is a distinction between people with mixed Indigenous ancestry and the Métis as a distinct ethnic group. Métis families and citizens are recognized as coming from distinct and historical Métis communities that shared a way of life and culture before effective control. The Métis Nation homeland includes parts of Ontario, Manitoba, Saskatchewan, Alberta, British Columbia, and the Lower Northwest Territories. Métis people in Ontario are unique as compared to Métis from other areas of Canada. Since they had access to the Great Lakes and waterways, their primary mode of transportation was by canoe. Métis people from Ontario also have their own Michif language dialects, which may vary between communities. The Métis are famous for their floral beadwork and are often called the flower beadwork people. Métis artists blended European floral embroidery, First Nations quill work, and European beads to create a style of floral beadwork that continues to be recognized as distinctly Métis. The picture here shows a traditional moccasin design and an octopus bag. These bags hold tobacco, a pipe, tinder, and other essential tools for being on the land. The Métis flag predates the Canadian flag by 150 years. At a gift-giving ceremony in 1814, Northwest Company partner Alexander MacDonnell presented the Métis with this flag, which soon became a trademark for the nation. The infinity symbol featured on the flag represents the joining of First Nation and European cultures and the immortality of the Métis Nation. The sash has been a symbol of Métis heritage for more than 300 years. It blends First Nations finger weaving techniques with European design and wool. The Métis share the sash with at least 2 other groups claiming it as a symbol of nationhood and cultural distinction. Eastern Woodland Indigenous peoples wore it as a sign of office in the 19th century, and French Canadians wore it during the Lower Canada Rebellion in 1837, and of course, Le Bonhomme du Carnival in Quebec City wears a sash. The sash now symbolizes how the lives of the Métis are interwoven through traditions, beliefs, and cultures. Other important elements of Métis culture include fiddle music and my favorite, the Red River Jig. The Supreme Court of Canada's decision in Powley affirmed that Métis people are protected under Section 35 of the Constitution Act of 1982. The facts of the case took place in the historic Métis settlement of Sault Ste. Marie, Ontario. The court set out the Powley test, outlining 3 factors to identify rights-bearing Métis citizens. First, the individual must self-identify as a member of a Métis community. Second, the individual must have an ancestral connection to a historic Métis community. And third, there must be acceptance of that individual by the Métis community. The Métis Nation of Ontario grants citizenship on the basis of the criteria set out in Powley. MNO citizens identify as Métis. They have an ancestral connection to a historic Métis community, and the MNO registry ensures that all citizens meet this criteria. Some people who identify as Métis may not be MNO citizens. If people want to access rights and programs exclusively available to MNO citizens, they are welcome to apply for citizenship through the registry. That said, MNO's advocacy programs are status inclusive. They are available for all persons who identify as First Nations, Métis, or Inuit. And I'm going to pass the presentation to Maria.
Thank you. So advocacy programs seek to ensure that Métis disaggregated data, trends, and their unique experiences of colonization are accounted for. This is part of the ongoing advocacy being done by our policy team members. Limited Métis-specific data have been collected to identify root causes of Métis and Indigenous overrepresentation in the legal system. The Royal Commission of Aboriginal People identified 4 possible reasons for overrepresentation among all Indigenous groups. The first possible reason is colonialism. So from the time of early French and British, many mechanisms of colonial control have been imposed, including violent relocation to reserves and other designated settlements and restrictive legislation, most commonly through the Indian Act. And just for a little quote here, colonialism in its various forms, whether residential schools, removal of people from their traditional lands, the dictates of the Indian Act, or the failure of government to honor the treaties, has had and continues to have profound negative impacts on Indigenous people. These impacts are manifested in many ways, including crime and victimization. The second possible reason for overrepresentation is socioeconomic marginalization, being a direct result of colonialism. So Indigenous communities have past and present lower rates of employment, lower income rates, substandard levels of housing, education, and healthcare. These social determinants of health are factors contributing to commissions of crime. The third possible reason for overrepresentation is systemic discrimination, being another direct result of colonialism and is a complex issue where widespread racism has been acknowledged as a concern at every stage of the legal system, including policing, courts, and corrections. And the final possible reason for overrepresentation is culture clash, so between Western versus Indigenous concepts of justice. So since 2010, the Indigenous inmate population has increased by 43.4%, and the non-Indigenous inmate population has decreased by 13.7%. This graph here just demonstrates the rapidly growing rate of federally incarcerated Indigenous people since 2001, evidence of the overrepresentation of Indigenous persons in Canadian prisons. In 2000, Indigenous people made up 17% of inmates in federal, provincial, and territorial prisons. In 2014, 20% of inmates in federal prisons and 26% of inmates in provincial and territorial jails were Indigenous. In 2016, 1 in 4 men and 1 in 3 women in custody were Indigenous. And today, Indigenous peoples make up about 5% of the total population in Canada, yet they represent 30% of the federally incarcerated population in the country. And the statistics shown in the previous slides show a trend of increased incarceration for Indigenous peoples over the last 10 years. And this slide here just focuses on more contemporary figures from Ontario during the COVID-19 pandemic. So throughout 2020, 2021, and 2022, there was a large decrease in incarceration. However, this did not affect Indigenous people in the same proportions as non-Indigenous people. The number of non-Indigenous people incarcerated from 2019 to 2021 decreased by 8,095 persons, while the number of Indigenous inmates admitted only decreased by 707 people. In fact, the percentage of Indigenous inmates admitted into custody increased from 10.57% in 2018 to 2019 to 18.65% in 2021 to 2022. So the M&O Advocacy Program has some tips for interacting with Métis people in the legal system. So 1, don't assume someone is or is not a First Nation, Inuk, or Métis person. Always ask. 2, provide a safe space for Métis people to identify themselves by using a distinctions-based approach. So instead of asking a person if they are Indigenous, ask if they identify as a First Nation, Inuk, or Métis person. 3, recognize the importance of cultural identity. So First Nation, Inuit, and Métis peoples have unique histories, culture, values, and traditions. Although there may be similarities between communities, it is important to recognize that they are not all the same. Different communities, including different Métis communities, may have different cultural practices and traditions. So there is no single Indigenous culture or Indigenous perspective. This common misconception is called pan-Aboriginalism. Our next tip is just to be aware and understand the benefits of Indigenous support programs and make use of them. And finally, just appreciate the importance of using appropriate terms when communicating with a First Nation, Inuk, or Métis person. So First Nations, Inuit, and Métis peoples have their own unique cultures. Even within a distinct group, such as the Métis, culture is linked to their ancestral lands and communities. So the M&O advocacy programs were created to address a lack of culturally appropriate support and legal literacy for Métis persons in all areas of the legal system. They were created to address systemic discrimination of Métis within the legal system. This discrimination and racism is a direct result of the imposition of a colonial system of justice. They were created to address Indigenous overrepresentation in the legal system, legal literacy and awareness to help Métis people understand their rights, the need for a community reintegration model, which gives access to wraparound supports to address recidivism stressors. And they were also created to address education for justice stakeholders on Métis rights, including best practices for encouraging self-identification for Métis and other Indigenous identifying people. Métis advocacy programs are offered across Ontario, with the exception of the Métis Court Worker Program, which currently runs only in M&O Region 7 and 8, which is Barrie and Toronto and surrounding areas. So now I'm going to pass it back to Conlon to just go over our programs.
Thank you, Maria. The Métis Community Justice Program provides public legal information and education sessions on topics relevant to Métis communities and relays justice concerns of Métis communities to relevant government and community agencies. The advocacy program offers both Métis criminal court work and Métis family court work programs. The Métis court work program does not provide legal advice. Métis court workers act as advocates for justice-involved clients. They are able to speak on behalf of clients who are unable or unwilling to speak on their own behalf in court. Support is available for accused persons, victims, and families going through the court system. The Métis Court Work Program is available in Regions 7 and 8, as mentioned by Maria. Some examples of how the Métis court worker supports clients includes attending court appearances with the client and facilitating meetings with criminal justice officials for their case, as well as supporting clients with applications for legal aid, assisting clients with accessing appropriate court forms, providing general legal information about legal rights and processes, as well as advocating for Gladue factor considerations at court and ensuring the court understands the availability of Métis-specific programs and supports. The program is continuously working to build new partnerships and establish networks with Crown attorneys, duty counsel, and other key justice stakeholders in order to support clients effectively and to educate justice stakeholders on Métis justice supports. The Gladue Aftercare Program, available across Ontario, assists persons who are in contact with or who have recently been in contact with the criminal legal system. The program seeks to provide reintegration support to Métis individuals by assisting them in addressing recidivism stressors through a client-led action plan. The program may be offered to persons who are being released from incarceration or who have recently been released, are undergoing criminal proceedings, are completing or recently completed diversions, have completed a Gladue report or attended Gladue or Indigenous Peoples Court. Clients of the Aftercare program work with the aftercare worker to develop an action plan that is client-led and unique to their circumstances. The action plan supports culturally relevant access to services by internal M&O programs as well as external programs and services as required, for example, healing lodges. The aftercare worker facilitates the referrals and guides the client through the action plan, checking in frequently to assist with any barriers or obstacles. The objectives of the Gladue Aftercare program include addressing recidivism stressors to prevent reoffending, supporting clients with relevant community connections and services, ensuring clients have access to culturally appropriate program referrals, and facilitating mentorships with Métis elders and knowledge holders. The Métis Community Diversion Program helps Indigenous persons aged 12 and up who become involved in the criminal justice system, either pre or post-charge. This voluntary program is available to any Métis or other Indigenous identifying person who is willing to take responsibility for their actions and be held accountable for them through the community-based diversion process. Program goals include diverting Métis and Indigenous persons out of the justice system while empowering Métis people to make decisions about harmful acts that occur in their communities, as well as educating justice stakeholders about restorative justice principles and processes. The program uses Métis-led diversion circles to encourage conflict resolution and reintegration into the community. It allows participants to share their perspectives in a safe, culturally relevant space. The diversion coordinator creates clear ground rules for circle participants to speak openly. When participants feel heard and are shown compassion, they are more likely to extend that same compassion to those they've harmed. This allows for meaningful discussions about the harm caused and how healing can happen for everyone involved. The program is available at the pre-charge and post-charge stages, either formal or informal diversion. In a formal diversion, the Crown agrees to withdraw or reduce the charges as a result of the client's participation in the program. In an informal diversion, the client's participation in the program is taken into account after the circle has been held. The Métis Community Diversion Coordinator's role includes advocating for the diversion, particularly in the post-charge context. The Métis Youth Community Diversion Program is designed for Métis young persons under the Youth Criminal Justice Act throughout the various phases of the criminal legal process. The aim is to provide culturally appropriate, trauma-informed diversion and justice services to help Métis youth who become involved in the criminal legal system so they can find a better path forward and be supported along the way. The program can function as an extrajudicial measure or sanction, also referred to as EJMs or EJSs, as well as a formal or informal diversion. The Métis Youth Community Diversion Program, process, and client lifecycle are similar to the Adult Diversion Program. The program recognizes that young persons may require additional support throughout the process and aims to provide a meaningful experience by working in person with them as much as possible. Both the youth and adult diversion programs are status inclusive, available to all Métis and other Indigenous identifying persons. Restorative justice generally refers to a system of justice stemming from Indigenous worldviews of conflict resolution and restoring balance within communities. It is based on an understanding that crime is a violation of people and relationships and is based on principles of respect, compassion, and inclusivity. Restorative justice seeks to repair harm caused to individuals and the community by encouraging the offender to recognize the harm caused by the act, take accountability for that harm, be involved in open discussions, usually in a circle setting with the person harmed and community members to discuss the impact of the harm, both on the individual as well as the community as a whole. It also encourages the offender to be actively involved in repairing that harm by making amends with the person harmed as well as the community. The Crown Policy Manual says that prosecutors should understand the impact of colonization on Indigenous peoples and their communities, as well as the value of restorative justice. Restorative justice focuses on helping offenders take responsibility for their actions to restore balance in the community rather than just punishing them. It shifts from a retributive justice lens focused on punishment to a restorative justice lens focused on healing, making amends, and restitution. It considers the unique circumstances of both the offender, the person who caused harm, and the victim, or the person who was harmed, aiming for solutions that look to the future. The process connects all participants to services that support healing. Instead of an adversarial approach, restorative justice encourages participants to work together to solve problems and restore wellness in the community. The goal is to repair relationships and restore balance, as opposed to finding guilt and setting a punishment. Unlike other diversion programs, our program is facilitated by a Métis Community Diversion Coordinator with the assistance of Métis community volunteers. Volunteers share their Indigenous worldviews and unique lived experiences during the diversion circle to help the client make their action plan. The services are client-led, emphasizing agency and self-empowerment. The program takes a holistic approach to address each client's specific needs. It also supports healing for members of the community impacted by the harm. The program connects clients with culturally relevant supports and services through the Métis Nation of Ontario, as well as other service providers. The Métis Community Diversion Coordinator supports the client to complete their action plan. I'd like to pass the presentation back to Maria.
Thanks, Conlon. So this section of the presentation just describes the Métis Community Diversion Program process. So clients progress through the program through different phases, which follow the life cycle of a strawberry. To illustrate this, we commissioned Métis artist Chrissy Cameron. She is an M&O citizen in Northwestern Ontario, and she created this piece inspired by traditional Métis embroidery. The client life cycle is the journey a client takes from the start to the end of their time in our program. We chose a strawberry to illustrate the client life cycle because it represents community. Strawberries grow in clusters, showing how things are stronger when they are connected. Similarly, Métis communities grow and succeed through working together, sharing and supporting each other. The strawberry reminds us of the strength and unity in our communities, which is also shown in the diversion circle. So for the initial referral, otherwise known as the seed planting stage, the Métis Community Diversion Coordinator, which we call the MCDC, sets dates for our program intake, which happens in 2 parts. And the MCDC communicates timelines with justice stakeholders who may include police, duty counsel, the client's private defense lawyer, the assigned Crown attorney, and any other external service providers who have referred the client to the program. So at any given point in the process, the diversion coordinator may connect the client with programs and/or services dependent on their individual needs. Moving to our initial meeting as our germination stage, the diversion coordinator meets with the client to build rapport. The coordinator explains the process to the potential client, including their right to counsel before proceeding with the intake process, and our coordinator educates the potential client about restorative practices. For our intake meetings, so our sprouting stage, it happens in 2 meetings that can take up to 1 hour. So intake part 1 includes discussions about the incident, accountability, and any relevant supports. The potential client is assessed for program eligibility during our intake part 1, and to be eligible, potential clients must be willing to accept responsibility for their actions, which is usually assessed by getting the client to talk about what they did. And the potential client must be willing to be held accountable. So for example, are they willing to hear from the person harmed and take actions to repair the harm? And part 2 discusses any prior legal system involvement, things that led to doing the harmful act, as well as the client's experience as an Indigenous person. In advocating for the diversion in our seedling stage, the MCDC engages with justice stakeholders to support moving forward with the diversion. This may include negotiations with the Crown and discussions with the client's private defense counsel, who can help both the client and the Crown attorney to decide how the diversion fits with the court process. In preparing the diversion circle in our plant stage, the MCDC reaches out to the Crown attorney to see if the person or persons harmed will participate and how. The MCDC coordinates diversion circle dates with the person harmed, the client, the support person or persons, and the MCDP volunteers. The person harmed can participate directly, whether they sit in the circle, or indirectly by providing the coordinator an impact statement or have a person sit in the circle on their behalf. Getting to our diversion circle flowering stage, the diversion circle process includes conversation between the client, the person harmed, the diversion circle volunteers, the support persons if applicable, and the MCDC. The key outcome for the circle is to create an action plan that outlines the goals the client agrees to complete during projected timelines. The coordinator completes a circle report, which may be submitted to either the client's defense counsel or to the assigned Crown Attorney to review. The report includes a summary of the diversion circle process and lists any action plan items for the client to complete. And the diversion coordinator may recommend a withdrawal of charges on the basis of the diversion circle. So diversions for young persons are held in person whenever possible, and hybrid, so online callers are permitted, but in-person participation is strongly encouraged. Getting to our action phase, so our nearly ripe stage, the diversion coordinator supports the client to complete their action plan, and the diversion coordinator facilitates regular check-in meetings with the client to get updates on their progress and any barriers they may be encountering. The coordinator supports the client to complete their action plan, and like I just said, including addressing barriers that might become apparent after the plan is signed. Once the client completes their action plan, the diversion coordinator issues a letter and certificate stating that the client has completed their action plan. So clients who successfully complete the Métis Community Diversion Program are likened to a ripened strawberry. The Métis Community Diversion Coordinator may refer them to the MNO's Glad Do Aftercare program for additional support if needed. And I will pass it back to Conlon.
Thank you, Maria. This part of the presentation describes what happens during the diversion circle in more detail. We'll start with the diversion circle format. Note that actual seating arrangements may vary. First, we have the Métis Community Diversion Coordinator who facilitates the circle. Then we have the client, the person who caused the harm. At least one Métis Community Diversion Program volunteer who's trained specifically to sit in the circle and provide guidance from the Métis community perspective participates. The circle may include the person who was harmed. Though not mandatory, it is highly encouraged. This circle may also include support persons for either the client or the person who was harmed. For example, a family member or family members, or a friend or friends of the respective parties. Now we'll talk about the 4 phases of the diversion circle process: the reflection phase, community impact phase, action plan phase, and action phase. The reflection phase is about gathering information from the person who caused harm. This includes what harm took place, what led to the harm, the root causes of the harm, what the client was thinking at the time, what their needs are, and so on. After reflection, we move on to gathering information from the perspective of the person or persons harmed. That is, those who were harmed. And this could be the direct person harmed, but also community members, witnesses, or anyone else who was impacted by the harm. This phase is about learning about the impact that harm has had on anyone who is impacted and what their needs are. Participation of the person who was harmed is encouraged for a meaningful diversion experience, but again is not mandatory. The Métis Community Diversion Program is able to accommodate a few methods of involvement for the person harmed, including a victim-offender dialogue, where the person harmed is engaged in direct dialogue with the offender. This provides an opportunity for the person harmed to express their feelings, ask questions, seek answers, and share the impact of the harm on their lives. It allows the person harmed and the person who was harmed to have a direct conversation, fostering understanding and empathy. A second mode of participation can be through a victim impact statement. A person who was harmed which can may be given the opportunity to provide an impact statement, either in writing or orally, which outlines the emotional, physical, and financial effects that the offense may have had on their lives. This statement is shared during the circle to ensure that the harm caused is fully understood. And the third mode of participation can be through a support person or advocate. A person who was harmed may choose to have a support person or advocate present during the restorative justice process. This person can share the concerns, needs, and wishes of the person harmed during the circle. These persons can also provide insight into the impact of the harm and help facilitate dialogue between circle participants. During the action planning phase, after all sides have been heard and considered, we then focus on creating an action plan, which is essentially a structured healing plan of how the client will start to set things right and how they will address the root causes of the harm. The action plan is specifically tailored to meet the needs and circumstances of each client. Common items on action plans have included referrals to victim services, referrals to mental health or addiction services, reconnecting with culture, apology letters, etc. Action items are specifically based on the client's expressed needs as well as input from all diversion circle participants. The client signs off on the plan to agree that they will complete it. And after the diversion circle closes, the diversion coordinator issues a diversion circle report. Finally, in the action phase, after the plan has been made, the Métis Community Diversion Coordinator works with the client over a period of months to not only ensure they are completing their action plan, but to help with any barriers they may be facing in completing their work. And now we'd like to move on to share some of our program successes. In this first example, it shows how the Métis Community Diversion Program works in the pre-charge diversion context. It highlights the success that can be achieved through collaboration between justice stakeholders and the holistic benefits of the Métis Community Diversion Program's restorative justice process. A Métis youth was arrested for assaulting another youth at the local mall. They were referred to an external service provider by the police for a pre-charge diversion, as I said earlier, also known as an EJM under the YCJA. After the arrest, the youth was released. They had 1 week to report to the service provider or the matter would be referred back to the police. The service provider used a distinctions-based approach to support self-identification by the Métis youth. The Métis youth requested Métis-specific programming and was referred to the Métis Youth Community Diversion Program. Although the program is voluntary, a client can be referred back to the service provider or police if they do not engage. The client and their supports were highly engaged in this case. Collaboration between the Métis Community Diversion Program coordinator and the other justice stakeholders helped to optimize the process. This included being able to meet with the client in an appropriate space at a location that was accessible to them and help facilitate participation by the mother of the person harmed. During the intake phase, assessing the client's willingness to take responsibility for their actions and to be held accountable involved meaningful discussions about these concepts, which resembled in some ways a form of mentorship between the diversion coordinator and the client. The diversion circle included the reading of a statement by the mother of the person harmed during the community impact phase. In response, the client read an apology letter that they had prepared on their own in advance of the diversion circle. The client's apology letter was delivered to the mother of the person harmed through the external service provider after the diversion circle closed. The diversion circle helped the client's family to heal from historic trauma unrelated to the underlying incident that led to the client's arrest. The client completed their action plan in less than 2 months. The total time span between the time of arrest and the client's graduation from the program was just over 3 months. Now I'd like to hand it over to Maria to share another success story.
Thanks, Conlon. So this success story here just shows how the M&O's advocacy programs provide clients with full wraparound supports. It also shows how the Métis Community Diversion Program can function as both formal and informal diversion in the post-charge context. So we had an adult client that was referred to the Métis Community Diversion Program through the Métis Court Worker Program and Client's Defense Council. The client had charges for multiple assaults and multiple driving-related offenses, including operating a vehicle while under the influence, over 80, under the Criminal Code. After successful advocacy, the client's assault matters were accepted by the Crown for diversion, and the client's diversion circle included one Métis Community Diversion Coordinator and two Métis Diversion Circle volunteers. Diversion Circle participants helped support the client set meaningful goals for their action plan, and the client was referred to the MNO's Glad Do Aftercare program to support reintegration after their release that was reduced from 90 to 30 days in their custodial sentence. And now I'm going to pass it to our supervisor, Mitch, for our final few slides.
Awesome. Thank you so much, Maria. And thank you, Conlon, to the both of you for going over the information. It's very extensive. I think you guys did a great job, and you guys do a great job in your communities as well. So I appreciate that. So we're going to end the presentation here with some of the obstacles and challenges for effective restorative justice process. So I'm going to pull a statistic here from the Research and Statistics Division from the Government of Canada, specifically about restorative justice. And this was done in 2018. And it had stated that over half of Canadians, about 52%, reported low familiarity with restorative justice, and a further 30% noted moderate familiarity. So this means as practitioners, when we go into spaces where we are practicing restorative justice, we're implementing the principles, but we're also meant to educate the communities that we work with at the same time. So essentially starting it off as an education piece, but also trying to enact some of those principles that we talked about before. One of the key areas of pushback we get when we explain restorative justice to different communities across Ontario is that there's often concerns that this is a way to purposefully evade the criminal legal system. So basically the misconception is that someone who's committed harm in their community just says the right words, or, if they're doing it in a performative way, that they'll be let off with no consequences. And in our experience, we find that, faking a sense of accountability is actually quite a rare occurrence. And it's important for restorative justice and diversion programs to have a comprehensive system for establishing a client's level of accountability, so this concern is adequately addressed. Our practitioners have also found in their experiences that there have been those who have past criminal record are less likely to be referred to a diversion or restorative justice program. So this poses challenges for clients who have never had the experience of a diversion or restorative justice process, and have solely been processed by the criminal legal system on many occasions. So there's more work to be done, including direct advocacy to the Crown and police services, to change the perception that those with criminal records are any less deserving of restorative justice. And additionally, procedural barriers such as no contact orders, police undertakings may prevent participation by the person harmed in the restorative justice process. Often another misconception about restorative justice is that, it's just for the person who caused the harm or the offender in this context, and it only benefits them. But there's lots of research to show that it benefits the person harmed as well. So we are advocating for both parties to have this process essentially as well. So we talk about the obstacles and the challenges. Colin, if you want to go to the next slide, we're going to end off on a call to how to address these obstacles. We don't have all the answers right now. We're working in the field, but these are a few things that we wanted to touch upon. So in order for justice stakeholders and the community to fully embrace restorative justice practices and programs, they have to understand what that process looks like. Having meetings with key justice stakeholders like the Crown, police agencies, custodial institutions, legal aid, and legal clinics are a great way to start. Additionally, restorative justice often is derived from community impacts and input. So engaging the community for them to learn more about the process is a great way to decrease stigma and increase awareness about this process. The second point is we're currently doing the work on the ground, but having these conversations with the crowns and police agencies across the province, we reiterate to the clients who have prior criminal history are arguably in the most need of a restorative justice process, given that there's a strong indication of recidivism in the colonial justice system. So our program addresses the issues by providing the police and crown with a unique intake based on each individual client that advocates for the criminal diversion process as a more effective and alternative of the traditional criminal legal system. So that's a lot to say. Really condensed, what we're trying to say is, some of the pushback we get is that those who have, a long list of criminal convictions or interaction with the criminal justice system, that, it's been known before that they may not be qualified to be in restorative justice, but it's our opinion that they may be the prime candidate, given that their success in the colonial system hasn't been great up until that point. So when possible, community agencies, and this last point speaks to the collaboration between stakeholders. When possible, community agencies, justice stakeholders, restorative justice practitioners alike should find ways to collaborate. Effective collaboration has a myriad of positive outcomes, including more personalized and relatable services for the client and a stronger united voice for restorative justice practices. It's just my take, but I do think this can be done through frank discussions between stakeholders where gaps in services can be greater complemented by each other, where one lacks, the other can assist. So having those conversations between stakeholders, we believe, is a really important first step to alleviating some of these obstacles that clients are facing for restorative justice, but program delivery in general. It can definitely be applied there as well. So just to wrap up, we would just like to thank you for joining us again. I didn't see any questions in the chat, but we are absolutely welcome to take them now. Conlon, if you actually just want to bring us to the last slide there, I know folks, this is a lot of information at once. I also know that folks are going to be joining us watching the recording. So if you have any questions for us, you'll see my contact information there, as well as Conlon and Maria's as well. And any sort of referral information can go right to that justice email. And I think that's it. Maybe we might want to hold on for a couple seconds in case folks have any questions and put their hands up.
For sure. So participants, you are welcome to use the Q&A feature to type in questions, or now if you are feeling bold and brazen, you can take yourself off mute and give a verbal question as well.
This is great news for me and my team because it means that we did a fantastically thorough job. No questions at all.
Absolutely covered all of the bases.
That's
And
right.
so on that note, I want to thank you all for presenting and sharing your knowledge with us and sharing this process. I was really happy. One of my questions that I was thinking about was, what as a conference attendee, what are sort of my next steps to further this? And I appreciate that last slide to, put in that plug for advocacy and awareness and bringing an alternative method to decision makers, to bring those alternative justice methods back at, into the forefront, because certainly there is ample evidence of effective work being done. And so it's great to hear that. And so again, I'd like to thank our speakers, Mitch, Conlon, and Maria. And for our attendees, just a few closing notes. So in our conference platform, to join this meeting, you clicked on that B6 join button. If you go back to that platform, there is a survey button that you can click. It's a few kind of multiple choice bubbles to give us some feedback about this session that we will share with the presenters, as well as just for us to know how we can improve the overall conference experience. Another note for the conference attendees who are looking at tomorrow's sessions, in that platform space, there is a little calendar button as well. So you can give yourself prompts to say, these are the sessions that I'm planning on attending, and that'll go into a calendar to easily populate for future attendance. And I think that is it. There is a closing session at the end of the day. So at 4 o'clock today, there's a little closing for the conference today. And then we will see you all back here tomorrow. So with that, thank you so much again for the presentation and for our speakers, and have a lovely rest of the day, everyone.
Thank you so much, Ken.
Thanks, everyone. Thanks, Ken.
Thanks, Ken.